Dear students, I welcome you to today's lecture on the doctrine of ultra vires. Dear students, in today's lecture we are going to understand what is meant by the doctrine of ultra vires in the context of company law. We are also going to understand the consequences of an ultra vires transaction. Dear students, we shall also try and understand the exceptions to the doctrine of ultra vires. Dear students, we have to remember that in order to understand the doctrine of ultra vires in the context of company law, we have to refer back to the Objects Clause of the Memorandum of Association. The Object Clause is the most important clause of the Memorandum of Association because it lays down the purpose for which the company has been formed and the kind of activities or business it intends to carry on. The importance of the Object Clause lies in the fact that it determines the purpose and the capacity of the company besides its sphere of activities. Although express powers are necessary, a company may do anything which is incidental to and consequential upon the powers specified in the Objects Clause, and such acts shall not be ultra vires. The company should confine its activities within its stated objects and not beyond the Objects Clause. Dear students, we now come to the doctrine of ultra vires. The doctrine of ultra vires provides that the company should limit its activities within its stated objects. Thus, it is meant to restrict the powers of the company to its Objects Clause. Any act which is beyond the Objects Clause is ultra vires the company, that is, beyond the powers of the company and therefore void. It does not bind the company. Clearly, neither the company nor the other contracting party can sue each other for ultra vires acts. Any act which is otherwise ultra vires cannot be made valid even if all the members of the company ratify it. Ashbury Railway Carriage and Iron Company Limited versus Ritchie is a leading case on the point. The objects of the company in this case, as defined in the memorandum, stated that the company was established to sell or lend on hire railway carriages and wagons and all kinds of railway plants, etc., and to carry on the business of mechanical engineers and general contractors. The company entered into a contract with Ritchie, a firm of railway contractors, to finance the construction of a railway line in Belgium. The company, however, repudiated the contract on the ground that it was ultra vires the company. Consequently, Ritchie brought a suit for damages and breach of contract against the company. His contention was that the said contract was well within the terms general contractors used in the memorandum and was therefore within the powers of the company. That apart, the said contract had been ratified by a majority of the shareholders. The House of Lords, however, ruled that the contract was ultra vires and therefore null and void. Lord Cairns observed, and I quote, "The subscribers are to state the objects for which the proposed company is to be established, and then the company comes into existence for those objects only. Such a statement has twofold operation. It states affirmatively the ambit and extent of powers of the company, and it states negatively that nothing shall be done beyond that ambit and that no attempt shall be made to use the corporate life for any other purpose than that which is so specified. The term general contractors must be taken to indicate the making generally of such contracts as are connected with the business of mechanical engineers. If the term general contractors is not so interpreted, it would authorize the making of contracts of any and every description and would virtually point to the carrying out of the business of any kind whatsoever and would therefore be totally unmeaning. Hence, the contract was entirely beyond the objects in the Memorandum of Association. If so, it was thereby placed beyond the powers of the company to make the contract, and if the company could not make it, much less could it be ratified." Unquote. However, this doctrine was made much clearer in the case of Attorney General versus Great Eastern Railway Company. In this case, the House of Lords was of the view that the doctrine of ultra vires ought to be reasonably and not unreasonably understood and applied, and whatever may fairly be regarded as incidental to or consequential upon those things which the legislature has authorized or ought not to be held by judicial construction to be ultra vires, it would be void in allowing the company and its business which is incidental or which is ancillary to its objects clause. Thus, if the companies do not state incidental objects in the objects clause of the Memorandum of Association, they would still be taken into consideration while deciding the ambit of the company's activities or business. In Forrest versus Manchester Railway Company, it was held that a railway company having authority to keep steam vessels for the purpose of ferry could use them for excursion trips on the sea when they were idle. In Evans versus Brunner, Mond and Company Limited, a resolution was passed by a company manufacturing chemicals by which it authorized its directors to distribute $100,000 to universities and scientific institutions for the furtherance of scientific research and education. One of the members brought a suit against the company on the ground that it was ultra vires. The court held that the distribution of money for scientific research was favorable to the process of the company as chemical manufacturers and therefore incidental to the company's main object, hence intra vires and valid. The doctrine of ultra vires was for the first time applied in India in Jahangir R. Modi versus Samji Ladha, wherein the Bombay High Court held that the purchase of a joint stock company by the directors was ultra vires the memorandum of the company, as the company had not authorized them to enter into such deals. The Supreme Court of India upheld the doctrine of ultra vires in its decision in A. Lakshmana Swamy Mudaliar versus Life Insurance Company. In this case, the directors of the company had the power to make payment towards the charitable or any benevolent object or for any general public or useful objects. In accordance with the resolution passed by the shareholders, the directors paid Rs 2 lakh to a trust formed for the purpose of promoting technical and business knowledge. However, the company's business was taken over by LIC, and as such it had no business left of its own to promote. Applying the doctrine of ultra vires, the Supreme Court in this case held that the directors could not spend the company's money on any charitable or general object which they might choose. They could spend the money for the promotion of only such charitable objects as would be useful for the attainment of the company's own objects. Justice Shaw held, and I quote, "There must be proximate connection between the gift and the company's business interest," unquote. In Park versus Daily News Limited, a company disposed of its newspaper business and proposed, with the sanction of the general meeting, to distribute the purchase price amongst its ex-employees as a means to compensate them for the loss of their employment and pension rights. Even though the proposal was beneficial to the former employees, it was held to be ultra vires, as its purpose was not in the interest of the company's remaining business. Dear students, we now try and understand the main objects rule of construction. In Re German Date Coffee Company, the Memorandum of Association of the company in its objects clause stated that it was formed for the working of a German patent which would be granted for manufacturing coffee from dates, for improvements and extension of the said invention, and to acquire and purchase any other invention for similar purposes. The intended German patent was not granted. The company went ahead and purchased a Swedish patent and established working on it in Hamburg. Two shareholders of the company filed a petition for winding up of the company on the ground that the main object for which the company was formed had failed to materialize, and therefore the court should order the winding up of the company. The court accepted the contention of the petitioners and ruled that since the company's real object was to manufacture a substitute for coffee in Germany under a patent and it had become impossible to achieve, it was just and equitable that the company should be wound up. Dear students, we have to remember that the main objects rule has also failed to work. Cotman versus Brockham illustrates the failure of the main objects rule. In this case, the House of Lords had to consider a memorandum of a company which contained an objects clause with 30 sub-clauses. This empowered the company to carry on almost every conceivable kind of business. The clause ended with a declaration that every clause should be considered as a substantive clause and not limited or restricted by reference to any other subclause or by the name of the company, and none of them should be deemed as merely subsidiary or auxiliary. While expressing strong disapproval for the inclusion of such a clause, their lordships were compelled to hold that it excluded the operation of the main objects rule of interpretation. Bell House Limited versus City Wall Properties represents another classic example of the erosion of the doctrine of ultra vires rule, albeit in a different form. In this case, a company's objects clause authorized it to carry on any other trade or business which, in the opinion of the board of directors, could be carried on advantageously in connection with the general business of the company. Even though an objects clause of this kind does not state any objects at all, the court held the clause to be valid. Dear students, we now come to the exception to the doctrine of ultra vires. A brief analysis of the doctrine of ultra vires with regard to its consequences would reveal that only those activities of the company shall be valid, that is intra vires, which are essential for the fulfillment of the objects stated in the main objects clause of the Memorandum of Association, which are incidental and consequential to the main objects, that is, which are reasonably within its permissible limits of business and which the company is authorized to do by the Companies Act in the course of its business. All other activities of the company, excepting the aforementioned, shall be ultra vires and therefore invalid. There are, however, certain exceptions to this doctrine, which are: number one, an act which is intra vires the company but ultra vires the directors, that is, outside the authority of the directors, may be ratified by the shareholders in proper form. Number two, an act which is intra vires the company but done in an irregular manner may be validated by the consent of the shareholders. The law, however, does not require that the consent of all the shareholders should be obtained at the same place and in the same meeting. Number three, the company's right over a property acquired by means of an ultra vires transaction shall still be secured. Number four, while applying the doctrine of ultra vires, the effects which are incidental or consequential to the act shall not be invalid unless they are expressly prohibited by the Companies Act. Fifth, there are certain acts under the company law which, though not expressly stated in the memorandum, are deemed impliedly within the authority of the company and therefore they are not deemed ultra vires. For example, a business company can raise its capital by borrowing. Number six, if the act of the company is ultra vires the Articles of Association, the company can alter its articles in order to validate that act. Dear students, we now come to the consequences of an ultra vires transaction. The consequences which may follow as a result of an ultra vires transaction undertaken by the company are: number one, injunction. The members of the company can apply to the court and get an injunction to restrain the company from going ahead with a transaction which is ultra vires the company. Number two, the directors may be held personally liable. The funds of the company can only be utilized for carrying out its authorized objects. Emphasizing this point, Lord Herschel in Trevor versus Whitworth observed, and I quote, A company cannot employ its funds for the purposes of any transaction which do not come within the objects specified in the memorandum." Unquote. Accordingly, if a director of a company makes an ultra vires payment, he can be held personally liable and compelled to refund the money. In re Sharpe, the directors of a company paid interest on shares out of capital, which was an ultra vires act. Consequently, the company was wound up. The court held that the liquidator could compel the directors to repay the money to the company. The shareholders of the company can bring an action against the directors to compel them, that is the directors, to restore to the company the funds of the company which they have used for transactions for which the directors had no authority to enter into without making the company a party to the suit. Where the directors have intentionally misused the capital of the company, they may be personally sued for fraud or deceit. Number 3. Breach of warranty of authority. The directors are akin to the agents of the company and therefore can do nothing which the company itself cannot do under its memorandum of association. Consequently, any contract which is ultra vires the company will be void and without any effect whatsoever. As such, directors must act within the limits of the company's powers. If they do not, they would be held personally liable for breach of warranty of authority. In Weeks versus Propert, a railway company floated a debenture exceeding its authorized borrowing power. The plaintiff offered a loan of £500 on the basis of the advertisement. The directors accepted it and issued to him a debenture of the company. The loan, being in excess of the borrowing power of the directors, was ultra vires and therefore void. The plaintiff sued the directors. The court held that the directors, by inserting the advertisement, had warranted that they had the power to borrow, which they in fact did not possess. The directors were therefore held personally liable for breach of warranty of authority. In case of deliberate misrepresentation, the directors may also be held criminally liable. Fourth, property acquired through ultra vires dealings. Where the money of the company has been used in an ultra vires transaction in order to acquire any property, the company's right over such property shall remain secure. Fifth, ultra vires contracts. The ultra vires contracts are void ab initio and therefore cannot become valid by ratification or by estoppel. Justice Gray has observed, and I quote, "Performance on either side cannot give an unlawful contract any validity, nor can it be the foundation of any right of action upon it." Unquote. He further held that in case of any ambiguity in the memorandum of a company, it should be interpreted against the company and in favour of the public in general. In Beaufort John, London Limited Re, the memorandum authorized the company to carry on the business of costumiers, gown makers and other allied activities of similar nature. The company undertook the business of making vignette panels, which was clearly ultra vires, and it opened a factory in Bristol for this purpose. 3 firms which had supplied money and material to set up the factory sued the company for the recovery of their money. Since the vignette panel business was ultra vires the company, the contract was void and the plaintiff could not make the company liable and the petition was dismissed. Sixth, liability for ultra vires acts under the law of torts. There is ambiguity as to the extent to which a company can be held liable for damages resulting from its ultra vires acts. But the law, as it stands today, makes a company liable under the law of torts if it is shown that, number 1, the activity in the course of which the alleged tort has been committed falls within the ambit of the memorandum of the company, and number 2, the tort was committed by the servant within the scope of his employment. To conclude, dear students, we have to remember that the doctrine of ultra vires implies that the company should restrict its activities to those mentioned in its objects clause. Thus, it is meant to confine the powers of the company to those activities that are contained in its objects clause. An act which is ultra vires is void and does not bind the company. Neither the company nor the other contracting party can sue each other for ultra vires acts. Even if all the members of the company give assent to an act which is ultra vires, it will still be invalid or void. The permissible range of corporate activity is indicated in its statement of objects. Everything else beyond that is implicitly prohibited so that the corporate capital may be preserved for the benefit of the shareholders and creditors. Pertinently, under Section 245, Clause 1, Subclause A of the New Companies Act 2013, the members and depositors of the company can file an application before the tribunal on behalf of the members or depositors for restraining the company from committing an act which is ultra vires, the Articles of Association of the company or the Memorandum of Association of the company. Dear students, with this we come to the end of today's lecture. I hope you have fully understood the concept of the doctrine of ultra vires, the exceptions to the doctrine of ultra vires, and the consequences of an ultra vires transaction. This is all with regard to today's lecture. Stay blessed.